executions. His reports will indicate that the reprimand was not without effect. The defendant Adolf Ott commanded another unit in Einsatzgruppe B, and he tells us, during the time I was commando head of Commando 7B, about 80 to 100 executions were carried out by this commando. I remember one execution which took place in the vicinity of Bryansk. The people to be executed were handed over to my unit by the local commandant. The corpses were temporarily buried in the snow and later buried by the army. The valuables which were collected from these peoples were sent to Einsatzgruppe B. Other units of Einsatzgruppe B, headed by the defendants Klingelhofer and Six, did not vary from this standard pattern. Einsatzgruppe C did not fail to report the success of its work. Under the significant heading, Executive Activities, this group reported in the first days of November. As to purely executive matters, approximately 80,000 persons were liquidated until now by the commandos of the Einsatzgruppe. Several retaliatory measures were carried out as large-scale actions. The largest of these actions took place immediately after the occupation of Kiev. It was carried out exclusively against Jews with their entire families. But the Jews were by no means the only part of the population which was marked for extermination. They were only the most helpless victims. Therefore, Einsatzgruppe C stressed the point of the political sources of danger by reporting, even if an immediate 100% exclusion of the jury were possible, this would not remove the political source of danger. The Bolshevistic work depends on Jews, Russians, Georgians, Armenians, Poles, Russians, Ukrainians. The Bolshevistic machine is by no means identical with the Jewish population. In this situation, the goal of a political police security would be missed if the main task of the destruction of the communistic machine were put back into second or third place in favor of the practically easier task of the exclusion of the Jews. Einsatzkommando 5 was commanded by the defendant Schultz. Only half a year after this commando had begun its activities, it was able to report a total of 15,000 executions. It was reported that the liquidation of insane Jews represented a particularly heavy mental burden for the members of Schultz's Einsatzkommando, who were in charge of this operation. Nor were the non-Jewish inmates of insane asylums spared. Einsatzkommando 6 killed 800 of them in one asylum alone. The commander of this unit at a later time was the defendant Bieberstein. Before he became leader of Einsatzkommando 6, he was a Protestant minister, and under his aegis, 2,000 to 3,000 helpless people were murdered, and he himself supervised executions which were carried out by his unit by means of a gas fan. The headquarters staff of Einsatzgruppe D is in the dock. The commander was the defendant Ohlendorf, and his deputy was the defendant Seiber. Ohlendorf's adjutant was the defendant Schubert. A subunit of Ohlendorf's command, Einsatzkommando 12, was commanded by the defendant Naska. A third unit of Einsatzgruppe D, Sonderkommando 10B, was led by one Perstra, who is now deceased. Perstra's deputy was the defendant Ruhl. During the first 9 months of Ohlendorf's year in command of Einsatzgruppe D, this force destroyed more than 90,000 human beings. These thousands, killed at an average rate of 340 per day, were variously denominated Jews, Gypsies, Asiatics, and undesirables. Between 16 November and 15 December 1941, this Einsatzgruppe killed an average of 700 human beings per day for the whole 30-day period.
Laws of war has never been territorial. Sir Hartley Shawcross, the British prosecutor at the international trial pointed out that the right of humanitarian intervention on behalf of the rights of man trampled upon by a state in a manner shocking the sense of mankind has long been considered to form part of the law of nations. German law professors, too, declared this in their writings. The jurisdictional power of every state extends to the punishment of offenses against the law of nations, quote, by whomsoever and wheresoever committed, end quote. It is therefore wholly fitting for this court to hear these charges of international crimes and to adjudge them in the name of civilization. The nature of the charges. The charges we have brought accuse the defendants of having committed crimes against humanity. The same acts we have declared under count 1 as crimes against humanity are alleged under count 2 as war crimes. The same acts are, therefore, charged as separate and distinct offenses. In this, there is no novelty. An assault, punishable in itself, may be part of the graver offense of robbery, and it is proper pleading to charge both of the crimes. So here, the killing of defenseless civilians during a war may be a war crime, but the same killings are part of another crime, a graver one, if you will, genocide, or a crime against humanity. This is the distinction we make in our pleading. It is real and most significant. To avoid at the outset any possible misconception, let us point out the differences between the two offenses. War crimes are acts and omissions in violation of the laws and customs of war. By their very nature, they can affect only nationals of a belligerent and cannot be committed in time of peace. The crime against humanity is not so delimited. It is fundamentally different from the mere war crime in that it embraces systematic violations of fundamental human rights committed at any time against the nationals of any nation. They may occur during peace or in war. The animus or criminal intent is directed against the rights of all men, not merely the right of persons within a war zone. At a recent conference for the unification of penal law, the definition of crimes against humanity was a leading topic. Document book, page 145, and offered as prosecution exhibit 29. I see there's another objection coming. I'll continue the quote later.
Dr. Bergold für Bieberstein. Hohes Gericht, ich möchte hier eine prinzipielle Ausführung machen. Ich habe aus den Dokumentenbüchern der Hohen Staatsanwaltschaft entnommen, dass gegen Bieberstein in der Hauptsache nur ein Beweis vorliegt, nämlich sein eigenes Affidavit, das der Vertreter der Staatsanwaltschaft eben vorlegen will. Ich habe über diesen Fall gesprochen und ich bitte mir vorzubehalten, Einspruchsrechte, die ich in dem gegenwärtigen Moment noch nicht genau spezifiziere.
The right to object. I cannot specify it exactly. I wish to ask this decision will not always followed according.
Document NO 3824, found on page 129 of the document book, page 159 of the German, and now offered as prosecution exhibit 31. Continue.
Dr. Heim für den Angeklagten Blobel. Herr Präsident, ich beantrage diese eidesstattliche Versicherung des Angeklagten Blobel.
Object to the affidavit by defendant Klobel. Document number 3824 only to be permitted under the condition that Mr. Waffenberg who took this affidavit may be interrogated, may be cross-examined. In this examination...
That's an inevitable right of every defendant.
Where they had to kneel down, their faces turned toward the grave. At that time, clothes and valuables were not yet collected. Later on, this was changed. The execution squad